Are you a tenant who's currently dealing with mold in your rental property? Are you worried about the impact this might have on your return on investment? Well, fear not. In today's episode of Legally Bound Business and Real Estate Explained, we will deconstruct mold lawsuits in Virginia, specifically the key issues that every landlord and tenant should know when it comes to mold liability in Virginia. If you find this video helpful, please be sure to like and subscribe. First, it's critical to fully grasp what the Virginia Residential Landlord-Tenant Act states about mold. You'll find the crucial sections of the VRLTA dealing with mold in the description box below in this video. Remember folks, mold is ubiquitous in nature. It is everywhere. The issue is whether the mold in your rental property is generating toxic byproducts like Aspergillus penicillin at levels that pose a threat to human health and safety. Next, understand the significance of a move-in inspection report. Section 55.1-1215 of the VRLTA discusses the disclosure of mold in dwelling units. The VRLTA requires landlords to disclose to the tenants if there is visible evidence of mold within the dwelling unit's accessible interior areas. If mold is detected, the tenant can choose to terminate the tenancy or request the landlord to remediate the mold. If no mold is found during the initial move-in inspection, then Virginia Code 8.01-226.12 states that there shall be a rebuttable presumption that no mold existed at the time of the move-in inspection. This can be a critical fact when establishing liability in the event of a lawsuit. Third, recognize the respective rights and duties of both the tenant and the landlord under the VRLTA. The tenant has a duty of, quote, reasonable efforts under the Virginia Code. This involves maintaining the rental property and preventing accumulation of moisture and mold growth. Plus, the tenant must notify the landlord immediately upon discovering any mold. Correspondingly, the landlord also has a duty of ordinary care related to mold remediation. Landlords are required to maintain the premises to prevent mold growth and respond promptly to any notices from a tenant regarding mold. If the tenant must vacate the property during mold remediation, you, the landlord, may have to bear the cost of providing a comparable dwelling unit or a hotel room as chosen by you, the landlord. When selecting a professional mold remediation company, remember that the VRLTA requires mold remediation to comply with the EPA's professional standards. It's not a task to be delegated to your local cleaning company. Instead, opt for a certified mold remediation company or an industrial hygienist to do the right job. Finally, if your tenant threatens to file a lawsuit against you for violating the VRLTA, make sure to contact our office immediately. We're here to help. Remember, your tenant cannot just stop paying rent. If your tenant files a tenant's assertion, then the rent would have to be escrowed with the court for the judge to decide whom to award it at the end of the trial. If you found this video informative, please don't forget to give it the thumbs up and subscribe to our channel. And also, please don't forget to see our next video on the invisible landlord by clicking this link below right here. Thank you and see you in the next video.